Greetings, welcome back to another video. Now, this will be two parts. I don't like to make my videos too long because I understand people's attention span ain't that long. So this will be delivered in two parts because it's a nice amount of information. Now, someone reached out to me last year. They were going over their mortgage documents and they seen some things that didn't fit right with them. And they wasn't in trouble or anything at the time. They wasn't facing foreclosure. They was actually current, and they wanted to address the issues of the incomplete contracts with their trust. So they reached out to my company and wanted to hire us as the substitute trustee, which we greatly obliged, and we offered information based on the experiences of things that we are used to dealing with. So here recently, we noticed a corporate assignment that was recorded upon the property. So we decided to look and investigate. Then I happened to receive a notice of a petition, and that's what brought about this content. So please understand that I'm not an attorney, nor do I offer or do I give legal advice. The information that I share is always just from my personal experiences with things. All right. So just please understand that I cannot help you if you are in a bad situation already and you need to seek legal advice or competent counsel. All right. Now, with no longer ado, please understand, like I said, this will be two parts. Let's get to it. Now, I know there are some people that may say, hey, they don't have to accept it. They can just start acting in the role or position and all that good little stuff. So let's check out some of their rules. All right. So this is the North Carolina statute. Looked up by just simply typing in, the office of trustee. And we have right here, let me zoom in a little bit so we can get a nice, good view of that. This is their subsection 36C 7-701, accepting or declining trusteeship out of Article 7. All right, except as otherwise provided in subsection C of this section, a person designated as a trustee accepts the trusteeship. 1, by substantially complying with a method of acceptance provided in terms of the trust, or 2, if the terms of the trust do not provide a method or the method provided in the terms is not expressly made exclusive, by accepting delivery of the trust property, exercising powers, or performing duties as trustee, or otherwise indicating acceptance of the trusteeship. B, if a person designated a trustee who has not yet accepted the trusteeship may reject the trusteeship. A designated trustee who does not accept the trusteeship within 120 days after written notice to accept the trusteeship is provided is considered to have rejected the trusteeship. So in my past video where I sat there and told you that there was a non-acceptance, right, of contract offer, please go check out that video so you will see this is the state of North Carolina we're talking about here. So anybody watching this video, make sure you check it out for your state if you are up under a deed of trust so you understand the rules and regulations of that deed of trust. Now, a person designated as trustee without accepting the trusteeship may act to preserve the trust property if, within a reasonable time after acting, the person sends a rejection of the trusteeship to the settlor, or if the settlor is dead or lacks capacity to a qualified beneficiary. So this is the first time we heard the power of a beneficiary being mentioned in actual legal document, and that's when after the settlor is gone. Inspect or investigate trust property to determine potential liability under the environmental or other law or for any other purpose. Then we have trustee bond. But that's all we're going to read for right now because that's all I wanted to show you, just to show you how the research goes for investigating these types of things. Now, I share a lot of information with y'all because I want y'all to understand just how easy it is to find this stuff. And the games that are being played against us, it just doesn't make any sense when we actually read the paperwork and see what's really going on, in black and white. So with that, no further ado, let's go ahead and get to the next part of this video. All right. So now we have pulled up here substitution of trustee full reconveyance. This was filed December 7th, 2023. All right. And we have, it was done by the / grantor and trust settler, right? Grantor / trustor and settler without recourse. Substitution of trustee for reconveyance, all right? Whoever this name was, acting in the capacity of what? Settlers for MERS as beneficiary under the certain deed of trust, duly substitutes and appoints who? Stand Strong Investments as trustee under the said deed of trust. And having received from furnisher, who was the furnisher? The one that started all of this. They furnished something to the trust, to the trustee, of the consideration there under a written request to reconvey, reciting that all sums secured by said deed of trust have been what? Fully paid by the recording of the promissory note as a registered security and said deed of trust, and that the note or notes secured thereby having been surrendered to said who? Trustee for cancellation, does hereby reconvey without warranty to the persons or persons legally entitled thereto the property now held by it thereunder. Said deed of trust was executed by the grantor / trustor to MERS, original beneficiary, and First Signature Lending LLC as lender, recorded in the official records of Cherokee County, North Carolina, as follows. That we have that date information, all right? North Carolina. All right, so this is what we have, and in witness thereof, Stand Strong Investments LLC as the substitute trustee. All right, so we have a substitute trustee on file. This is the only trustee that has accepted the fiduciary role and acted on behalf of this trust with regards to by who? Capacity of the grantor / settler, the person that created the trust, settled the trust, and they executed this document. They're the only signature on file, so their signature is the only signature that has legal authority to do anything. Here's this notarized. Substitute trustee for reconveyance, signed, trustor and settler. Done deal. All right, now let's take a look at this other document that's recorded on their record. We have an affidavit and memorandum of real estate purchase agreement. And this is between the sellers as well as the buyer, which is before me. The undersigned authority on this day personally appeared, who being first duly sworn disposes to say that a real estate agreement was entered in October 18, 23 by and between these two, which are the seller and Stand Strong Investments, who was the buyer, for the real estate property located at this address. A copy of the real estate purchase agreement between the seller and the buyer, as well as the agreement between buyer and Diamonds List Express Trust Enterprises, established in the territory of Texas, which provides DLETE, a contractual interest in the property may be obtained by contacting us at this address. So this is why we received notice in the mail. So they obviously went and checked the record and seen that there was something else going on with this property before they tried to steal it. Okay, in order to satisfy this encumbrance, a release of interest must be obtained from DLETE. All right, for the affiant, say if not, signed, sealed, and delivered in the presence of the affiant. And here we have a notarized document as well. All right, you see the date on that, November 2023. And then we scroll on down, we have the property description. And then we also have a note recorded. Whoop. All right, let's just glance over this note. You see the date on it. It's April 28th of 2023. And I want to show you a key special thing of this note for the $222,000. Notice the payment says the payments will be made on the 1st of each month beginning June 1st, 2024, which as of today has not transpired. But even if it did, this note has been recorded and the whole mortgage has been settled and reconveyed back to the original owner. And this is notarized and dated. All right. So you see here, they do not have any standing. All right. There you have it. So we have here pulled up a piece of mail that I received from some LOGS legal group of certified mail. Scroll on down here to the first page of the document. Here we have some type of court petition in the state of North Carolina, Cherokee County, the General Court of Justice, Superior Court Division, in the matter of the foreclosure of a deed of trust executed on April 28th and recorded in the book, all that good stuff. Substitute trustee is LLG Trustee LLC. Where did this substitute trustee obtain power and authority to sell property from? And they're filing a notice on a foreclosure for a particular deed of trust. You are hereby notified, Clerk of Superior Court, North Carolina, they shall conduct a hearing. Okay, reaching out to us, let us know there needs to be a hearing. They want to hear what's going on, pursuant to the North Carolina General Statute, Section 452116, with respect to the foreclosure of certain real property as hereinafter set forth. Okay, now they're saying the holder, okay, catch that, the holder has instructed the substitute trustee. Find that interesting because I am the substitute trustee and I was also the holder. So how could this be? In the above described deed of trust to institute foreclosure proceeding pursuant to the power of sale. The power of sale contained therein because of a default and the failure to make payments on the principal and interest on the promissory note secured by the deed of trust. You mean the promissory note that we've already recorded and settled on this deed of trust? Dated April 28th, 2023, and the principal sum amount of $222,000. Okay, 2. The holder has accelerated the maturity. No, I have not. Of the debt secured by the above described deed of trust. The holder has confirmed in writing. No, I have not. To the undersigned that within 30 days of the date of original notice, debtor would send first class mail, lada. The underlying mortgage debt evidenced by the note and the deed of trust, not a home loan as defined by NGG or its whatever that says. We're going to keep going through all that. Now, here we go. You have the right to appear before the office of the clerk. So we have the right to stand and, let's show them what we have versus this bullcrap they have, right? At the Cherokee County Courthouse, 75th P Street, Murphy, on June 6th, okay, 11 a.m., at which time you shall be afforded the opportunity to show cause as to why the foreclosure should not be allowed to be held. Well, you certainly right, we will. To authorize foreclosure, the clerk must find the existence of a valid debt of which the party seeking to foreclose is the holder. 2, default. 3, right to foreclose under the instrument. 4, notice to those involved or entitled to notice. Well, they sent me a notice. So they obviously know that I am what? The true substitute trustee. Where else did they get my information? They had to go on the record. 5, that if the loan subject to this proceeding is a home loan, the pre-foreclosure notice and information required by the NCGS 45102, 45103 have been provided in all material respects and all relevant time periods have been elapsed. 6? The sale is not burned by any person other than an active military. All right, let's keep scrolling. At the time of hearing, you shall be afforded the opportunity to show cause why the foreclosure should not be allowed to be held. We certainly will. To authorize foreclosure, the clerk must find the existence of a valid debt. Okay, that's what we all just read. All right, then we have 6, subject to real property sold by the substitute trustee at the place designated for the sale. All that good stuff. If you do not intend to contest, see, a lot of people, they won't even contest this stuff because they just don't know how, right? Because we don't be knowing what's going on, but we know what's going on over here. You do not have to appear at the hearing, and your failure to attend at the hearing will affect neither your right to pay the indebtedness or to prevent the proposed sale, nor your right to attend the actual sale. You could elect to do so. If you elect not to appear at the hearing, the substitute trustee will ask the clerk for an order to sell real property being foreclosed. As substitute trustee, our office is a neutral party and cannot advocate for the holder or servicer in this proceeding while acting as substitute trustee. So you heard this who's saying this, right? Let's scroll down to the bottom. Who's saying this? Aaron Gabby, an attorney for this LLG trustee company. Okay, so they're basically saying they're neutral. So since they're reaching out to me, you best believe I'm going to respond. And let's just see how I'm going to respond. I'm going to respond. All right, we have substitute trustee supporting affidavit for the notice of hearing on the foreclosure. I hereby declare under the penalty of perjury under the laws of the United States of America and the state of Texas that I am of sound mind, having reached the age of majority and capacity to state the following statements is true on or around November 21st, acting in the capacity of settlers for MERS as beneficiary under said deed of trust, duly substituted and appointed Stand Strong Investments as trustee under the said deed of trust. Now, I understand that's the names has been redacted to protect their information. So, two, I, as agent of Stand Strong Investments LLC, accepted the fiduciary responsibility within 120 days. Within 120 days. Remember, we read the law of North Carolina about that within 120 days. And having received from furnisher of consideration the settlers thereunder a written request to reconvey, reciting all sums secured by the said deed of trust have been fully paid by the recording of authenticated promissory note as a registered security and deed of trust, and the note or notes secured thereby having been surrendered to Stand Strong Investments as trustee for cancellation and conveyance without warranty to the persons or persons legally entitled thereto, the property now held by it thereunder. The said deed of trust was executed by the grantor truster to MERS, originally beneficiary, and First Signature Lender LLC as lender, recorded in the official records of the Cherokee Records of North Carolina as follows. Date of the original deed of trust recorded May 1st, 2023. That's the instrument number. And it was registered and recorded on 21st as far as the authenticated promissory note to go along with it. All right, property address. This is the description. Past all of this. I, as substitute trustee, have been the only fiduciary who has been granted and accepted irrevocable power to sell said property, and I have not been instructed in the above mentioned reconvey deed of trust to institute any foreclosure proceeding pursuant to the power of sale contained therein because of a default in the failure to make payments of principal interest on the authenticated promissory note secured by the reconveyed deed of trust on this date in the principal amount of $222,000. I, as the only holder of the authenticated promissory note on record, have not accelerated the maturity of the debt secured by the above described reconveyed deed of trust. I, as the only holder of the authenticated promissory note on record, have not accelerated the maturity of the debt secured by the above described reconveyed deed of trust. I, as the only holder of the authenticated promissory note on record, have not confirmed in writing within 30 days of the date of any original notices to any debtor was sent first class mail to last place of known address any written statements of an amount of principal and interest that I, as the only holder, claims in good faith is owed as of date of any written statements. 6. There is not a debt obligation currently owed in regards to the reconveyed deed of trust and authenticated promissory note that has been settled as evidence upon the county records as substitute trustee for reconveyance accepted and executed by myself as the manager of Stand Strong Investments, LLC, on November 21st, 2023. In the spirit of understanding, I am of sound mind, competent, of legal age, of majority, to state the matter set forth herein, that the contents are true, correct, complete, certain, admissible as evidence, and reasonable and just in accordance with the affiant's best firsthand knowledge and understanding of events that took place back then and until now. I can also attest to the fact that it is also a fundamental principle of property law that a fraudulent conveyance is void and ineffective to transfer title, and the deed procured by fraud is void Abenito and conveys no title. This case law to support that. And we have signature, Stand Strong Investments, seal, and we have the signature of the notary for this document. All right, so that's how we rocking. Hope you're enjoying this so far. Peace and prosperity.